Wonderful. Right. Okay. So I just going to quickly introduce myself, just in case that, for some of you probably haven't met me before. So my name is Lucia Xiao, and I'm a property investment mentor and financial advisor. So I'm a mortgage advisor and also a insurance advisor as well. And also the founder of mortgages, Finax Mortgages and Insurance. Also, a couple of years ago, I published a book. And it's called Financial Freedom 5 Steps, 5 Years. So it's just a personal story of myself. Back then, we were living in a state house, and to later on, we actually built a $17 million property portfolio in 5 years. Yeah. And obviously now it's just continue to grow. And especially at the moment, we're working on some development projects. Yeah. So very exciting. This year or next year. Yeah. Okay. And absolutely, I do believe that if I can do it, I'm pretty sure that you guys can do it too. You just need more knowledge, and also you need some guidance, from us. Yeah. So joining us tonight is Jeff Ussher from Ping Chen lawyer firm. It's very well known, I think, in the community. Especially in Chinese community as well. And Jeff actually is litigation lawyer. So basically that he will represent his clients in court, and he's expert in this area. And I think he's absolutely enjoying it, winning the cases for his clients. Yeah. So I'm just going to, leave it to you, Jeff. Yeah.
Okay. All right. Hello, everyone. My name's Jeff Ussher, as Lucia has said, from PCW Law. You wouldn't know from my youthful appearance, but I've been a lawyer for 31 years, specializing in litigation and dispute resolution. PCW Law is your one-stop law firm. We do everything from property through to dispute resolution, litigation, immigration, wills, trusts, commercial, and everything else in between. So tonight we're going to talk about property disputes, which is something that's dear to everybody's heart, I think. So now, Lucia, I just need a little bit of technical help here on getting my slide where I can... perfect, here we are. All right. So property disputes covers a whole range of issues and a whole range of different properties. Your basic property dispute will often involve ownership issues, who owns a property, or more likely, does somebody have an interest in a particular property. Also, many of you will be landlords. You'll be familiar with tenancy issues, either commercial or residential. Another very, very big area of property law is relationship property. And sadly, since the last lockdown, we've seen quite an increase in relationship property cases where people have decided to separate. I think lockdown for some people brings them closer, and for other people makes them realize after a certain period of time that there's only so much time they can spend with each other before they get sick of each other. Cross-lease issues still arise, not so much now with more modern subdivisions, but sometimes we do still come across cross-lease issues. And another very common area of dispute is boundary issues, either where the boundary is or whether somebody, your neighbour, for example, has a building or some other part of their property encroaching onto your property. And also very common issues around boundaries are fencing issues and who is responsible for payment of payment for a boundary fence, for example. Now, the focus tonight, to some extent, is how to avoid these issues. You have remedies through the courts, and there's some various other ways to resolve disputes, and I'll talk about those in a little bit more detail later on. But the most cost-effective and efficient way to deal with a dispute is to avoid a dispute in the first place. And often that requires some thinking and some planning and taking legal advice at the outset, because whilst lawyers always want to take your money, we are very happy to take a smaller amount of money and help you prevent a problem in the first place than take very, very large amounts of your money later on if you get involved in court proceedings, for example. So you should legally vaccinate yourself and take some advice right at the beginning if you have a dispute, or indeed if you are dealing with particular properties. If you are buying a property with other people, you need to make sure that you have an agreement which properly sets out the proportion of the shares, what happens if somebody wants to sell their share in the property, for example. And there's an old saying which you will all know: prevention is better than cure. So it is far better to take advice at the outset and plan and set yourself up at the beginning than to have to deal with issues later on. One very, very common now, less so previously, but very common now in relationship property is for couples who are embarking on a new relationship to have what used to be called a prenuptial agreement, and is now simply what's called a contracting out agreement, where they are contracting out of the provisions of the Property Relationships Act. Not so common with younger couples, perhaps in their first relationship, but if, for example, you're a bit older, you've already been in a previous relationship, you've accumulated a lot of assets, your partner may have done the same, it's very sensible to set out in an agreement exactly what is separate property as you go into a relationship, so that you don't find that you've worked for 30 or 40 years to accumulate assets. You go into a new relationship, that relationship lasts for a few years, but you separate and then you walk out of it, and your partner is entitled potentially to 50% of the assets that you went in with. There are a number of ways to deal with the disputes if you can't avoid a dispute. Negotiation, litigation, which is legal proceedings, arbitration, mediation, Disputes Tribunal, which some of you may be familiar with, and the Tenancy Tribunal, which I'm sure some of you will be familiar with as landlords. So I'll just talk a little bit about each of those processes. Now, I think, as I've said in the slideshow there, conflict is a fact of life. Everybody gets into disputes, whether it's in their personal life or in their business lives. The most important thing when you have a dispute is to talk about it and deal with it early. Unfortunately, a lot of people will put their head in the sand and wait, by which time a problem has potentially escalated out of proportion to what it was before. So the most important thing to do is to communicate. Sometimes it's not possible to communicate person to person directly. You may need to get your lawyers involved. And one of the benefits of having a lawyer involved is that they can be objective and stand back from the dispute, because obviously if you are emotionally involved in a dispute, you're dealing with something to do with your own assets, your own property. It's often hard to divorce your emotional feelings from the commercial considerations that you need to bring to negotiating an end to a dispute. If you can negotiate a result at an early stage, it will save you time and money, and it will often assist you to preserve business or personal relationships, because disputes often arise in the context of an ongoing personal relationship. If, for example, we're talking about relationship property, or an ongoing business relationship. And it doesn't necessarily mean that simply because you've got a dispute that that relationship comes to an end. And in fact, it is often a very big driver in people's desire to resolve disputes, that they maintain the business relationship that they have. Sometimes, though, it is not possible to achieve the outcome you want simply by talking about it, and you may need to take legal proceedings. There are a number of different legal proceedings available. Liquidation proceedings against a company, it's not usually something that you would be dealing with in the context of a property dispute. There are a number of other courts or tribunals that you can go to resolve disputes involving property. There is the Disputes Tribunal, which is right at the bottom of the pecking order, District Court, High Court, and the Family Court is there to deal with relationship property proceedings. Now, the Disputes Tribunal is what used to be called the Small Claims Court. Lawyers are not allowed to be involved as advocates in the Disputes Tribunal. If you've got a dispute in the Disputes Tribunal, you've got to turn up and deal with it yourself. Although lawyers can be involved behind the scenes to help you prepare your case. The Disputes Tribunal can only deal with claims up to $30,000. So it is quite a cost-effective way to deal with smaller disputes. And the Disputes Tribunal can also deal with Fencing Act issues where the amount in dispute is $30,000 or less. Now, some of you will be aware that there is the Fencing Act 1978, which provides that if you have a boundary with your neighbour and there isn't a boundary fence, you can serve a notice on your neighbour requiring them to contribute half the reasonable costs of erecting a fence between your two properties. So that is quite a useful tool if, for example, you have a neighbour who is not willing to engage at all in talking about erecting a fence or something on the boundary to separate the two properties. There are certain procedures under the Fencing Act, and if your neighbour does not take the appropriate steps to dispute the notice within the required period of time, they will be required to contribute half the cost of the fence, and that is something that you can enforce through the Disputes Tribunal or through the court. Now, I have just switched to audio only mode according to my Wi-Fi. Can everybody still hear me at least?
Yeah, we can still hear you. Yeah, it must be the Wi-Fi signal or something.
It is a Wi-Fi signal issue. Yeah, hopefully that'll come back.
I think that's fine, yeah.
Yeah, okay. So I'll just give a brief description of some of the other courts which are commonly involved in dealing with property disputes. The District Court can determine proceedings where the claim is up to $350,000. Any claim over $350,000 normally needs to be commenced in the High Court. And the High Court also determines bankruptcy and liquidation proceedings. Bankruptcy for an individual, liquidation for a company, those are not usually processes which are involved in property disputes unless you have reached the end of the dispute, you've got a judgment that you need to enforce, and at that point you would be taking bankruptcy or liquidation proceedings. The downside to legal proceedings is that they get expensive. If a claim is defended, there are a number of steps to take, and it's common for a court proceeding to take between 1 and 2 years from the time you begin it until the time you finally have a hearing and have a judgment. There are steps that are taken along the way, such as discovery, where both parties need to exchange documents in their possession and provide a list to the other party of all relevant documents in their possession. It is very, very common for court proceedings to settle well before you have a hearing with a judge. As people get along the court proceedings track, they will understand that it becomes very expensive, and at some point they decide that they do need to have some discussions and see if they can save both parties some money and reach a resolution that people will live with. But if a hearing is necessary, you will have a hearing in front of a judge. Normally the parties need to give evidence together with any witnesses in respect of their case. Their lawyers will argue the case in front of a judge, and then the judge decides the outcome. There is also the Family Court, which decides relationship property proceedings. Sometimes such proceedings are also dealt with in the High Court. Now, there are some tools that you can use in the context of property proceedings. And sometimes these can be very effective in bringing proceedings to a close or getting you the result that you want without actually having to go all the way to a hearing. Now, for example, freezing orders, which can be used to freeze property if you are making a claim that you have some sort of entitlement or you've had some sort of contribution to that property. Freezing orders are most commonly issued against personal property such as bank accounts. But I have obtained freezing orders against real estate, against property in circumstances where property has been sold, where we said the property in fact belonged to a company in which our client had an interest but was effectively bought with our client's money and was then sold by another company. And it wasn't a case where our client directly had an interest in the property that would enable them to file a lodge a caveat against the property, and we obtained interim freezing orders against the property, preventing the property from being sold until the court determined the outcome of the claim. There are other remedies that you can use, and it is very common if you have what's called a constructive trust or an equitable interest in a piece of property. That is, again, something that some of you will be familiar with, where you can have a registered owner of a property, but somebody has contributed money to the property, and in the eyes of the law, they have what's called an equitable interest in the property, even if their name isn't on the title. And there are two ways in which you can preserve your position if you have an equitable interest in a property or you claim you have an equitable interest in the property. The first is to lodge a caveat, and that will be something, again, that a lot of you are familiar with. The second option is in the context of relationship property proceedings, where if you claim that you have an entitlement under the Property Relationships Act to part of a property which is in the name of your former spouse or former partner, you can lodge what's called a notice of claim. And a notice of claim under the Property Relationships Act is, in essence, the same as a caveat. It has the same effect, which is to prevent the property from being dealt with until either the parties reach a resolution or the court has determined the claim. Now, there are ways in which a caveat can be challenged, and what a lot of people are not aware of is that it is quite an easy process to issue what's called a lapse notice through Land Information New Zealand to try and get rid of a caveat from a property. If you issue a lapse notice through Land Information New Zealand, then LINZ will issue a notice to the owner of the property. And at that point, the owner of the property has only 10 working days in which to apply to the High Court or to the Family Court in the case of a notice of claim for an order that the caveat or the notice of claim not lapse. Now, those timeframes are very, very tight, and if you let them go by, you essentially lose the caveat or you lose your notice of claim, and it is very, very difficult to then lodge another caveat or another notice of claim, because you are not allowed to lodge a fresh notice of claim or caveat if they have lapsed without the permission of the court. So it is very important, if as a landowner you receive a notice from Land Information New Zealand that if you are a caveator, if you've put a caveat on a property, and if you receive a lapse notice advising you that your caveat or your notice of claim is going to lapse, then you need to see your lawyer immediately, because you need to take steps immediately. If you miss the deadline and do not get an application filed in the High Court or in the Family Court within that time frame, then the caveat will lapse, and at that point you are faced with having to go back to court and seek permission to put a new caveat on, which is not an easy task. I have been faced with some interesting situations where people are claiming an interest in property. I had one about 10 years ago, which ended up in the Court of Appeal, where we had two Chinese families, two Chinese brothers. One of them arranged for his brother to be imprisoned in China and then said to him, "Hey mate, what about all these companies in New Zealand? I will go to New Zealand and look after them for you." So the brother who was in prison, who didn't know his own brother had arranged for his imprisonment, said, "Yeah, sure, you go look after them." So evil brother went back to New Zealand and proceeded to take millions of dollars out of the company. When brother was released from prison, which was quite quickly, he went back to New Zealand, found that his companies had significant assets taken away from his brother by his brother, and he issued proceedings. So that went through court for about 10 years, and ultimately it was found that the brother had taken money from the company. In fact, he had admitted it, but his defence was, well, it was my money in the first place, which the court did not accept. So step number 2 was that I issued what was called a tracing claim, and that was on the basis that a property in Howick, which had been purchased by the evil brother and his wife and his daughter, had been purchased with money that they had admitted they had taken from my client's companies, and which were and which therefore in essence belonged to my client. And in the end, the Court of Appeal, the High Court found in our favour, and that was upheld by the Court of Appeal. But in the meantime, we had some very interesting arguments, such as, no, this money was bought by our we're using money saved by our 14-year-old daughter in China. She came to New Zealand with $100,000 US in a suitcase from her own personal savings, and that is what we bought the property with. So that was a very interesting hearing in the Court of Appeal, and it wasn't surprising that ultimately the court decided that no, they weren't going to believe that story, and it was far more likely that the property had been purchased by the money that had been stolen from my client's company. Now, while court proceedings can get expensive, they also take a very, very long time, which any of you who've been involved in proceedings will know. There's a saying we have in New Zealand, we have a court system, but we don't have a justice system. And proceedings can take a long time, and there is no guarantee that the judge will find in your favour, no matter how compelling the facts may be. So an alternative to the public court system is arbitration, which is essentially a private court process where you pay an arbitrator to make a decision. And the arbitrator's decision is called an award. It's final and binding on the parties, and it is enforceable through the courts. Now, there are a number of advantages of arbitration. The most important is that it is a lot quicker than court proceedings, and the parties have a lot of control over the procedure. You can decide what sort of hearing you have, whether you need to have a hearing in front of the arbitrator or whether it can be just on written submissions. You can choose the arbitrator to suit your case, and it may not even need to be a lawyer or a legal expert. It's often common in building disputes to appoint an arbitrator who is a building expert but that isn't a lawyer to decide the case. Now, related to arbitration is a process called mediation, which is essentially a facilitated negotiation. If, for example, you've had discussions with the opposite party but you haven't been able to reach a resolution, often a trained mediator will be able to help you to reach resolution using techniques that have been tried and proven over many years to bring parties together and reach an outcome that people can live with. So again, mediation is what's called alternative dispute resolution, as is arbitration. And it is a process which, again, you have a lot of control over, like arbitration. But the key point about a mediation is you have to reach an agreement at the end. The mediator is not an arbitrator, is not a judge, and does not make a decision which is binding on the parties. All the mediator can do is help you to try and reach a resolution. One of the advantages of mediation, again, is it can happen quickly, it can happen remotely, such as by Zoom. And in fact, it is common now, particularly during this lockdown, for court hearings to also take place via video link. I had a court hearing in the Court of Appeal 3 weeks ago, sitting here in front of my computer, 3 judges all in their homes over different parts of the country, the court registrar sitting somewhere else, and the lawyer for the other party sitting at his home. So it is possible, and it is becoming more and more common to have video hearings, particularly during lockdowns. So the courts are getting more modern and are adapting to the challenges of modern society, but they are still, in a lot of respects, still in the dark ages. And then there are some other courts and tribunals. I've talked about the Tenancy Tribunal previously, and I also note that the Tenancy Tribunal can deal with unit title issues of up to $50,000, as well as purely tenancy issues. And we've talked about the Family Court for relationship property disputes, and there are some specialist authorities and courts for employment disputes. If you have been to court, or you've had an arbitration, you've reached a result, then you then need to take enforcement action. Otherwise, your judgment or your arbitral award is really nothing more than a piece of paper. There are a number of avenues available to you to enforce a court judgment or an arbitration award. Bankruptcy proceedings. Now, a very useful tool, though, if the proceeding involved a property, is to put a charging order on the property. A charging order is something which you can place on a property once you have a judgment, and it is essentially like a caveat, and it prevents the property from being dealt with, but it has the added bonus of you having the ability to apply to the court to sell the property and have the court sell the property, particularly if you have a money judgment that needs to be satisfied. And there are some other orders that you can obtain. For example, you can have a debtor examined in front of the court as to what their assets are, as to their financial position, or you can seize other sorts of property such as furniture or motor vehicles by making the appropriate application to the court. So whilst you do have all those remedies available to you, I do want to reiterate again that what you really want to do is try to avoid disputes. So the key to that is communication. The key to that is addressing any issues early. The key is going to see your lawyer early, because, as I said, we like to take your money, but we prefer to take your money and find you an early and a cost-effective solution rather than a very long and protracted solution, such as, for example, going through the courts, in which case we will be taking a lot more of your money. And all of you who are in business or who are investing in property have much better things to do with your money than spend it on court proceedings. So really, that's the end of my presentation. I think we can probably open it up to questions now.
Right, so we've got a contact detail there that if you have any questions you want to reaching out to Jeff, yeah, okay. And I think we have John is asking for arbitration. Can the solicitors be invited for any parties?
The answer to that is yes. An arbitration is like a private court proceeding. Solicitors can be involved and usually are involved, particularly if the arbitration involves property that's of some value. So the short answer to that is yes.
Okay. And just, you keep talking about a caveat, so for caveat, is it only like for people who has an interest of the party that can do a caveat, or is it anyone can just put a caveat on on a certain property?
No, you have to have a caveatable interest. And there's two common ways in which a caveatable interest will arise. The first is if you've actually got a written agreement. For example, you agree to have an unregistered second mortgage on a property, at which point you've got an interest in that property. You can put a caveat on to support that unregistered second mortgage. The other common scenario where you would have a caveatable interest is if you have contributed money to that property, or if the property has been bought, for example, in the case of my warring brothers, bought by money which has been stolen or taken from you. In other words, if your money has gone into a property, then at least part of that property is considered to be held on a constructive trust by the owner of the property in favour of you. So, but you can't just put a caveat on, and in fact you have to be very careful putting a caveat on if you don't have a caveatable interest, because both the person putting the caveat on and the solicitor themselves who is lodging the caveat can be liable for damages if, as a result of that caveat, the property owner suffers loss. For example, they're unable to settle a sale.
Right. Yeah. Okay. So, like sometimes you might be buying a property and then might be 3 months to settle.
Yeah.
Like, is it a good idea to having a caveat, or it doesn't really matter because it's 3 months? It's not really a long time. Yeah.
It is quite common as a purchaser to put a caveat on the property, because that is another area in which you do have an interest. If you are a purchaser with an unconditional agreement, you do have a right, you do have an interest in the property, and you do have a right to put a caveat on, and it is quite common to do so. So
if it's you don't do it, is there any risk there that if you don't do it? Yeah.
Well, the risk, I suppose, is that the vendor might dishonestly sell the property to somebody else. I mean, that doesn't happen very often, but it is a reason for a purchaser or an unconditional purchaser to put a caveat on a property. And apart from it's not so much it is to protect your interest, but it's also notice to anybody else that if the vendor is wanting to then try and sell the property off to someone else, they do a title search and they see that there is a caveat there. If they search the caveat, they will see that it is supported by an unconditional agreement for sale and purchase.
Oh, right. Okay. Right. Okay. All right. I think we got another question here is from Sabine. I have crossed this property. I want to add a room. I asked consent letter from neighbor. My neighbor not happy to agree. How to deal with the neighbor? I don't think you can force him that. Yeah.
Well, you may be able to, because cross leases generally provide that you to do any sort of structural work, you do need your neighbour's consent. But most leases also provide that consent should not be unreasonably withheld. So if it's, not out of the ordinary, it's not going to really affect the neighbour's property at all, and it's something that you're getting consent for, it's already, you've applied for consent for the council, and that a cross lease isn't just a veto on any work that your neighbour can do. You cannot unreasonably withhold consent. So the first thing to do obviously would be to talk to them about it. If they are not cooperative, then you may want to see your lawyer and ask your lawyer to write a reasonably friendly letter in the first instance, pointing out the provisions of the cross lease. But of course, the first thing you do have to do is check the provisions of the lease and make sure that it does provide that consent to building works, for example, isn't to be unreasonably withheld.
Oh, right. Okay. So it's not just come with it. It's just like you need to check the lease
Correct. First. Because a cross lease is exactly that. It's two basically identical leases which apply. You're leasing the property from me and I'm leasing the property from you. So that your starting point is always the terms of the lease.
Okay. Yeah. So you do have to check that lease and see whether it's got a clause there that your neighbors is they shouldn't be unreasonable withhold that consent to you. Yeah. If that's the case, then you can actually maybe ask them nicely and pointing it out. Yeah. And then if not, of course, you can contact your lawyer and they can actually just, write a letter. Yeah.
Correct. Yeah. And it's always, particularly with neighbour disputes, you want to keep it nice if you can. You've got to live with these people. They're next door.
That's true. Yeah. Okay. All right. So I think follow on, I think John's asking, like, could you please provide an example that is in relation to boundary issued, such as seeking consent from neighbours and council?
I'm not sure what John's issue is. You wouldn't need consent from council normally if you're just going to put up a boundary fence and it's within the height restrictions. But are we talking about a boundary dispute? If we're talking about a dispute over the boundary and where the boundary is, then obviously your first port of call is to talk to the neighbour. You would want to have a look at the title and where the plan on the title provides for the boundary to be. If it's really uncertain, you may need to get experts involved, such as surveyors. But again, your starting point would be to talk to your neighbour. And then if your neighbour is uncooperative, I would go to your lawyer, who would then be able to assist you in identifying exactly what issues there are and what you need to do. I think John said, set up retaining wall between boundary. A retaining wall is a bit different from a fence. So yeah, that is something that you would need consent normally from the council, I think, for a retaining wall.
Okay. All right. And we got Chris here was asking, like, are you seeing any legal dispute with level 4 in Auckland and purchasers being unable to complete a settlement because they can't meet lender requirements, or vendors being unable to vacate tenants during level 4, or any other issues relating to challenges in settling as level 4 prohibits banking valuations, tenants moving in and out?
We have seen some disputes. By and large, people try and find a practical solution and accommodate each other. But yes, we are finding issues like that. We are finding people, for example, where you can settle, but you cannot give possession under level 4 because you may not be able to provide the key. But we're often finding modern houses, of course, often have electronic keys, so you don't need to provide the key. One of the things that you and I were talking about before the seminar commenced was the difference between an agreement which has a COVID clause and an agreement which doesn't, because most sale and purchase agreements that are being entered into at the moment will provide that if you are in level 4, then settlement automatically is deferred until you're in level 3. But yes, we do find that there are a number of issues, and you have to really approach each case on its own merits and talk to your lawyer about it. But two issues that have been raised, particularly coming out of last year's lockdown before there were any COVID clauses at all in contracts, were people trying to rely on what's called a force majeure clause, which is act of God, and arguing whether or not a pandemic was an act of God, which therefore allows the contract to be cancelled or to negotiate some sort of deferral of settlement. And the other is a legal concept called frustration of contract, where you say that you're simply unable to complete the contract. But in 99% of cases, an argument for frustration in these circumstances is not going to succeed. It is a very, very high threshold to argue frustration. So you would certainly, I think, want to, if you're entering into any new agreements, make sure that you've got a COVID clause in there to protect yourself from this sort of dispute later on, because we never know when the next lockdown is going to be.
Okay. Right. So we got we got another question from Cindy. Is, hi, my neighbor's tree roots are pushing the fence to my side. Yeah. And the fence is about to fall down. What can I do?
Well, your neighbour's tree roots are not allowed to encroach on your property, and they're not allowed to damage your fence. Again, step number one would be to talk to your neighbour about it and ask them nicely, look, you've got to trim these roots away. You may have to make an arrangement for them to be able to have contractors to come onto your property so that they can trim their roots or remove them from your side of the property. If, however, they're not cooperative, then again, I think you go see your lawyer, who should, write to them and point out that you are simply not allowed to have tree roots encroaching onto your neighbour's property. Encroachment itself is something which is not allowed, even if there is no damage. I think in Cindy's case, we've got a second level where her fence is also being damaged by the encroachment. So she's obviously going to be suffering some losses, and that's something that the neighbour may have to think about compensating or paying for reinstatement of the fence.
All right, okay. Question from Eddie was asking, my neighbor didn't pay the rent in full for several weeks now. How should we do to avoid loss? That's more like Tenancy Tribunal.
This is a tenancy. Well, the short answer is you can go to the Tenancy Tribunal if your tenant has not paid the rent, and then seek an order either that they pay the rent, or you can seek an order evicting them from the property. If it's several weeks, it does sound like it's not something that's going to remedy itself, and it doesn't sound like it's a temporary or short-term issue. I mean, you're obviously in a position where you're not going to be able to go to the Tenancy Tribunal or get someone out during level 4, but really the Tenancy Tribunal is the place that you need to go for your remedies under the Residential Tenancies Act.
Yeah. And I think often we kind of suggest the customer that don't, trying to managing their own property, because it's just so much issue there, your time, energy, and also your money as well. It's better leave it to the professional. Although that yes, you're paying a bit of fee, but it's actually really, really worthwhile to do. Because it's saving you all the time and energy, and also remember saving you money. Just imagine like this situation, you're probably unable to recover those money. So question from Malcolm is asking, a survey has determined that a boundary fence with a neighbor is built within our property. We intended to do a development. How do we handle the moving of the fence in the neighbors if the neighbors is reluctant?
Step number 1 would be get your lawyer involved. Again, I hate to sort of say, hey, come see your lawyer, but the reality is people will take a lot more notice if your lawyer is involved. The short answer is if your neighbour is absolutely reluctant and simply won't deal with it, then you do have the right to go to court and get an order that the fence be moved if it is encroaching in your property.
Right, okay. A question from Cindy. Is any authorized organization to regulate the commercial lease? If any issues or dispute where we can seeking for help, such as break the fixed agreement? I don't think so.
No, I mean, a lot of commercial leases have what's called an arbitration clause, which requires the parties, rather than to go to court, to engage a private arbitrator to deal with the dispute. I don't think there's any particular organisation which has the ability to simply go and regulate commercial leases. You would have to engage some sort of formal dispute resolution process, whether that's arbitration or through court, if you're simply not able to resolve it by negotiation.
So commercial is very different from residential, because residential is like there's a tenancy tribunal, but not in commercial.
Correct, that's right.
All right. So Kaylee is asking, is prenuptial agreement is still effective with partner being together over 10 years?
If your prenuptial or your contracting out agreement says that it is to cover the relationship, then yes, it shouldn't matter how long you've been together, and really that is the point. Normally what you are doing with a contracting out agreement is establishing what separate property you're going into the relationship with that does not become relationship property. So I don't think it matters how long you've been together, as long as your contracting out agreement has been properly drafted to ensure that it covers the duration of the relationship.
So does it mean that if they've been together for 10 years, they can still drop out the prenuptial agreement, is it? Or they had to do this
I think
before?
Cindy's question was, is it still effective? But there's no law which says, after a certain period of time, a prenuptial or a contracting out agreement is not effective. But you would have to make sure that it's drafted properly to be effective. Yeah.
Okay. So Cindy is asking, so what is the maximum height for the fence on the boundary? I don't know.
Well, I think that's a question to find out from the council, I think, in the first one.
So Cindy, you can ring council. I think the number is 09 301 0101. It's very easy to remember. Yeah. So 09 301 0101. Yeah. Okay. So Rachel, hi, my neighbor's tree fell over and crushed our boundary fence. Yeah. Am I legally bound to pay half the fence repair fee, or am I entitled to ask my neighbor to pay the full amount?
That is a very interesting question. My gut feeling is your neighbor should be paying for it. It is their tree which fell over, but that is a very interesting question. This isn't the case of a fencing and unfenced property. I would certainly, if I were you, not be contributing to the repair of the fence. I would let your neighbour pay for it. And if they were then coming to you saying, hey, you need to pay half of it, at that point in time, you'd be probably wanting to say no and then wait to see if they take any further action. I would certainly not in that situation be paying for the fence.
Right. Okay. So Eddie was talking about the property is managed by professional agent, and it still happened. Yeah. So I guess that if they're actually kind of walking through that and ask them, what's their plan in place, and like if they are a good property manager, they should be able to recover those money, from the tenants. Yeah. Okay.
Yeah.
And Naresh is asking, we bought our first home a month ago. Four of us share a driveway, and all of us own 1/4 of that lot. Yeah, but our neighbor is not allowing us to park our cars, saying this area are only for them to park cars. Yeah, since we are new, we didn't want to create an issue, but they have marked their parking space in that common lot. Are they allowed to do that?
I think the short answer is you'd have to actually come and see your lawyer and get them to look at that. That will depend on whatever the terms of the easement are, or if it's a unit title, exactly what the common property is and how it's been defined under the body corp rules and the plans for the unit title. It's not something I could answer off the top of my head, but it sounds like it is an issue you do need to get sorted out.
So what happens if they do find out that it's a common area? So would it be the better way is they need to talk to the neighbor nicely, and then if not, maybe have to come to the lawyer? Well,
again, that's right. I mean, it will all depend. I mean, there will be documents which determine exactly what the use of that particular part of the property is, but somebody's going to have to sit down and look at that and figure that out.
Yeah. Okay. All right. Is asking, if you are with your partner for 7 years, but not living together, does that make it a de facto relationship?
That is a very interesting question. Normally, a de facto relationship is defined as in the nature of a marriage, and that normally means you are living together, you're in a sexual relationship, all of the sort of defining features of a marriage. If you are living apart, I'm not entirely certain whether that would make it a de facto relationship. You really have to look at all of the circumstances because, there are a number of things can be involved. Are you not living together but you spend every weekend together, or you spend every week together and then you go back to your own homes at the weekends? That is something that would need to be looked at in more detail, but it is a very good question, because whether or not the Property Relationships Act applies will have a big impact potentially on your assets, and whether or not those assets are shared with your partner or remain your separate property.
Yeah. So I don't know what you're trying to achieve there, but I think, it's always a good idea to talk to the lawyer and see
Mm.
what, can they do, because obviously they understand all the laws, and then, I mean, either way they can represent it, they can actually fight for any points, yeah, for either parties, yeah. Yeah. Okay, so we got another question from S. Is my drainage was blocked. Both private plumber and water care have confirmed it was caused by the blockage at the neighbors. Yeah, tenant and the neighbor's house advised their drainage has been blocking for weeks. My plumber and water care unlocked the drainage, but the landlord from next door, what's it? Rescue to pay, is it? Yeah. What should I do?
I think refused to pay.
Refuse to pay, yeah.
Yes. Well, again, if they're refusing, I guess I come back to my standard answer: go talk to your lawyer.
The problem is to talk to the lawyer is very expensive. They're charging you out.
It is. You may want to take them to the Disputes Tribunal. Because,
There's a under $30,000.
Yeah, and if you've got evidence that, however, I'm just not entirely certain that the Disputes Tribunal, I mean, it depends whether or not what you're looking for is to recover money that you've paid or some sort of order, because the Disputes Tribunal has very limited power to make orders for people to do things. Its main powers are to order people to pay money. So if, for example, it is a case of requiring the neighbour to take action to stop blocking your drain, then that may be something that has to go through the district court. And that is, again, something you probably want some assistance from your lawyer.
I think in this case, most likely is like they just want to recover the money they pay, yeah. Yeah.
If that's the case, if it's under 30,000, go to the Disputes Tribunal.
Yeah. And I don't know how much costing you, because obviously going to the dispute tribunal does require your time and energy. Like you probably had to get a day off or whatever. I don't know. Yeah. So you probably had to wait. I don't know how much that bill is. Yeah. Okay.
Yeah, agree with you.
Right. Wow. So Cheryl's got the hi, good presentation. Question: we have an easement on the driveway. We are the dominate tenement over the right of way on the driveway. My neighbor is servient tenement. When we develop our land, do we have to get approval from the neighbor? The driveway is 6 meters wide, even though it is a shared surface of the driveway. During and after the build, we don't need to use neighbor's side driveway at all. Would a dominated tenement has more right than so it must be the easement there. Yeah. Okay. And again, do we have to get approval from the neighbor's consent to subdivide and build?
Right. Well, there's a lot in there, and I'm afraid to say I'm a litigator and not a property specialist, and that is above my pay grade. But we do have some very, very experienced property lawyers at PCW Law who I'm sure would be very happy to assist you to work out the answer to that question. But I'm afraid that's not something off the top of my head that I can give you an answer to.
Yeah, it sounds like, they cannot give the neighbors right to use the driveway.
Yeah.
But do they actually need to get approval from the neighbors? Yeah.
Well, yeah. And again, these are the sorts of things where you've got to see all the relevant documentation. You've got to see the titles, because there's a danger in giving an opinion off the cuff. Yeah.
So you do have to read through all those legal documents, and probably worthwhile to actually just talk to the PCW Law, okay. So Lily is asking if a prenuptial agreement can be signed after 10 years in relationship. Does the couple need to pay partners casino's debt or business debt? Might be too late for the prenuptial agreement.
Yeah. I think that depends on whether it is relationship debt or not, and if you're talking about if you're having a contracting out agreement partway through a relationship, it is not something which is a pre-nuptial, if you like. It is what you would call contracting out. And if you are contracting out of the Property Relationships Act, then you can put whatever provisions you want in there within reason. So, you know, because that is the whole point. You are contracting out of the default position of the law. But yes, I would have thought that you would not want to be paying your partner's casino debts. For example, you would be wanting to make sure that those are defined as personal debts or separate debts as opposed to relationship debts.
Yeah. Yeah. Okay. Yeah. Yeah. All right. I don't know whether we had any more questions, because I think you were talking about some interesting things about the you know, like it was during the the CCC is not issue, and then the purchaser can actually taking the legal action against the vendor that, you know, they are not really active or taking a reasonable step to make that happen, or yeah,
that is a very common scenario at the moment, because obviously with property prices going up, and if contracts have been entered into a while ago, we are often seeing a situation where vendors really want to get out of the contract because they know they can go sell the property to somebody else for a much higher price. And purchasers, of course, desperately want to keep the contract because they know they're going to get a property which is worth far more than what they originally agreed to pay for it, or that they can also go sell to somebody else and immediately make a profit. There is often what you call a sunset clause in an agreement, particularly subdivision agreements, for example, so that if, for example, a CCC isn't issued within a certain period of time, the vendor has the right to cancel the contract. But normally, if you have a provision which is there for your own benefit, you do have to take all reasonable steps to ensure that that provision is fulfilled. You can't just, as a vendor, say, oh, if I just wait until the CCC was due and take no steps to even apply for a CCC, then I can cancel the contract. That's not how it works. And we are often finding situations where purchasers will make accusations against the vendors that the vendors have not taken all reasonable steps, for example, to obtain CCC, and that therefore they are not validly cancelling the contract under the sunset clause. And there are more and more instances of those being challenged, again, for the reason that the vendor wants to be able to sell to someone else, and the purchaser definitely wants to keep the property and proceed with the purchase.
So how the purchaser they are able to show the evidence that, you know, the vendor hasn't done the the property steps? Well,
normally, of course, they would ask the vendor to say, hey, you need to tell us what your can you still hear me okay? I've gone back.
Yeah, I can hear you. Yeah.
Right. Normally you would be asking the vendor to provide evidence as to the steps they've taken to satisfy the condition. But a worst case scenario, if you end up in court, which if you're dealing with high value properties, sometimes you do end up in court, then again we come back to this process called discovery, where both parties have to provide copies to the other side of all relevant documentation. And at that point, the vendor, whether they like it or not, and whether it's in their interest or not, will have to provide all evidence of the steps that they have taken to obtain the CCC, for example. And of course, the flip side is if there is very little evidence that they've taken any steps, then the inference is, well, they haven't really done enough.
Right. Okay. Yeah. So they had to prove that they are innocent. They did. They had actually done a proper step.
Not so much that, but you do have to prove that you've taken reasonable steps. You don't have to prove that you've done absolutely everything on the face of the earth to obtain a CCC, but you've got to prove that you've taken reasonable steps.
Oh, okay. Yeah. So those cases, have you actually been able to actually help the purchase to actually continue to secure the property? Yeah.
I haven't been involved in cases with purchaser in that exact situation, but we have had a couple of cases recently where we've been acting for vendors who are saying, yes, you know, we have taken all reasonable steps, but we still haven't been able to obtain the CCC in time.
Oh, so you were helping the vendors to get out of the contract, is it? Yeah.
Yes, well, helping them with the dispute. Yeah.
Oh, yeah. Okay, yeah. So I think that's how good a lawyer, they can represent the either party, yeah.
Yes, that's our job.
If they're a good lawyer, it doesn't matter.
You're good or bad, that doesn't matter to us. We just represent you. Yeah.
Yeah, okay. All right. So we got the question from Lynn was asking like, can a prenuptial agreement be signed after 10 years in relationship? I think many people are trying to I think he already answered that it's not a prenuptial anymore. It's called contracting out. Yeah. Agreement.
Yeah.
Yeah. Yeah. So yes, you can still have some sort of agreement, but it's called contracting out agreement. Yeah.
Correct. That's right.
Yeah. So we got also Ping is all right. So your boss is trying to answering some question here. So, yeah. So yes,
thank you, Ping.
Right. Yeah. So basically, you can sign a contract out agreement at any time, no matter how long you have been living together as a couple. Yeah. So I think that's Ping just answered the questions here, Lynn. Yeah. Okay, so Lily is asking that, sorry, what's the difference between prenuptial agreement from contract out agreement towards the third debt party, casino, the casino debt or others?
Well, there's no difference. A contracting out agreement, we don't call them prenups anymore. So again, I mean, if you want to contract out of that debt, then you can. I mean, obviously, your partner has to agree.
Yeah. Yeah. Okay. Oh, I think that's awesome. Yeah. I think that's wonderful. And maybe just talk about a quick, chat about a commercial lease. I don't know. Have you actually come across like a bit of commercial lease dispute or something? Yeah, especially with the the lockdowns, and probably there are people out of business. They're probably trying to get out of contract or yeah.
Yeah, we do have a lot of commercial disputes, commercial lease disputes, and one of the most common disputes is how much discount on rent and outgoings you are required to give under clause 27.5. Which is a clause in the standard ADLS agreement, which provides that if you cannot access your premises, then the landlord needs to give you a reasonable reduction in rent and outgoings. And of course, under level 4, generally, unless you are an essential service, you cannot access your premises. So there's usually no dispute that some sort of discount has to be given, but of course, there is often a dispute over how much that should be and whether or not it's fair or reasonable. We are seeing that a lot.
All right. I think our the current lease, they kind of give us a 50% on the rent, but they still want us to pay 100% on the outgoings and also the car park. Yeah. So isn't this being probably not really reasonable, isn't it?
Well, I mean, I can't comment on that because, what's reasonable in every circumstance is completely different. What the contract says is discount on rent and outgoings. But of course, if you're getting, say, 50%, or we got one client who was offering 80% on rent, but no discount on outgoings. So my argument would be that a 0 discount on outgoings is reasonable in the circumstances where you're getting an 80% discount on rent.
Right. Okay. So it's hard to prove that what's reasonable and not reasonable.
Very, very difficult. And I haven't seen a lot of court cases on it yet because people are not wanting to probably go to court and spend, huge amounts of money just arguing over what's reasonable because, what's a judge going to do anyway? Flip a coin in some circumstances. So it would have to be involving a very, very large and significant commercial tenancy before it would be worthwhile going to court and asking a judge to decide.
Yeah. Because when you look at it, it might be only just costing you like, $3,000, $4,000 or whatever a month, so it's probably not that worthwhile. Yeah.
Correct. That's right. And also, of course, you've got both landlords and tenants who are under a lot of financial pressure as a result of lockdown. So nobody wants to spend their money going off to court arguing over what might be a few $1,000s difference.
Yeah. And how about the people if they kind of like, because, like, unfortunately, they had to shut down the business. They had to cut short in the business. But they committed to this lease. Are they able to get out of that lease, or just in no way that they are able to just,
The short answer to that is usually no.
Yeah.
Once you're in a lease, you're committed to the end of the lease term, except in very exceptional circumstances.
Right. Yeah. Okay. Cool. All right. Then I think that's probably like us for tonight. And I don't know. Jeff, do you have anything else you want to share, or?
No, that's it. I think just again to reiterate, we are here to help you. PCW Law is a one-stop law firm. We can help you with all of your legal needs, no matter where it may fit in the spectrum, and we're always very willing and happy to talk to you about your issues.
Thank you so much, Jeff. Yeah.
No problem. My pleasure. And thank you.
Yeah.